All right. Well, thank you all for being here this evening. I know it's getting late in the day, and this is not the most exciting topic, but it is kind of, there's death and taxes. So we'll talk about, not taxes. There's a little bit of taxes included. But I'll try to also keep it as entertaining as possible. I would first like to thank Texel for giving me this opportunity to talk with you, and I hope you do find this to be informative. I will give that disclaimer that none of the information here is legal advice. This is purely informative information. All right, so we'll get on with the program. The topic of today is, or the title of today's talk is, what is estate planning and how does it apply to me? So the things that we'll cover are, what is estate planning, who needs estate planning and when, what documents are included in an estate plan, what are non-probate assets, and then we'll talk a little bit about trusts. So what is estate planning and the factors to be considered? Estate planning is financial planning targeted at how to best own or hold property during our lives and how to best transfer property to loved ones or charities during life or at our death. An estate plan is one part of an overall financial plan. Some of the factors that you would want to consider when you're preparing your estate plan is, how do you want to pass on your property? Thinking through, who do you want to receive the property? Does it have to all go to your spouse? Does it all have to go to your children? Can it go to other people? What about your pets? Family dynamics and players. Again, do you want everything to go to all of your children? Or maybe there's that one child that maybe we don't want to receive quite as much, or we want them to receive certain things but not these other things. Taxes. We would all like to just say, nah, don't have to worry about taxes. Can't completely get there, but there's some creative planning that we can do to help us minimize the taxes to our estates. Asset protection. So if there's concerns about creditors, debts, there's some things that we can do to try to help. You can't evade it, but you can help protect certain assets in the future. And then there's certain unique assets that you might want to think about. The family ranch, the family business, certain things that really create that estate that you want to protect, not just for yourself and for your immediate family, but thinking about things down the road. And then public benefits and special needs planning. And this is really where we start talking about, how do you protect your spouse or maybe your children if they are going to need things like Social Security, Medicaid, other public benefits. And so how do you make sure that your estate is protected and that their public benefits are protected? All right, so who needs estate planning and when? Just a kind of a quick question. Do you think that the 18-year-old new adult, fresh out of home, do you think that they need a full estate plan? They probably don't own a whole lot. They're just kind of getting a fresh start. Do you think that they need a full estate plan? Probably not, no. So if you think about the size of an estate and certain things that are within the estate, that's where you start thinking about, what do I need to create for the estate, or what do I need to have in place for my estate plan? We'll get to some other questions related to that 18-year-old though, because maybe they do need some things, but we'll get there later. Sometimes kind of benchmarks where you can start thinking, oh, I need to think about like the whole portfolio, and we'll get to what's in that portfolio of estate planning. But some of the key things that you want to think about are when you get a new home or you acquire some amount of property, when you get married or remarried, when you move to a new state, and we'll talk about why that could be important as we continue on. When you have a new baby or you adopt or in some way grow your family, when you start a business, and then once you have your estate plan in place, you want to review that every 3 to 5 years. Doesn't mean you have to change anything, but it's worth reviewing. My husband and I recently updated all of our documents because we're at a point where our parents are getting older, and we'd named our parents as guardians for our children. And we have a 2-year-old. My parents are not going to keep up with the 2-year-old. And so we weren't going to ask that of them. And so we had to go back and do some revisions and redo our estate planning. So it's good just to look back every 3 to 5 years, give it a once over and update as needed. The estate planning package. What documents are in the estate plan? And every law office attorney will do it a little bit differently, but these are some of the things that I include in a package. First is your last will and testament. I think most of us are familiar with that one. It's a big one. Through the last will and testament, we provide for ways that all of our assets are distributed upon our death. And then it also could contain provisions to minimize death and estate taxes, like we talked about before. It can provide for a trust for managing property for children who are not of mature age or who have special needs. And so we talked about earlier, you can set up a trust that would put assets from your estate into that special needs trust. And then if somebody needed to have access to public or qualify for public benefits, the special needs trust holds it in a certain way so that they can still hopefully qualify. As far as the trust for children, and we'll go back into this a little bit more, but the unique thing is that you can't have a child under 18 inherit certain properties or property. They're not an adult yet. And so once they reach 18, they can inherit. But you think about that big asset, whatever it might be, your fancy sports car, your big house, your, large bank account, whatever it is, do you really want that 18-year-old to get his or her hands on $500,000 bank account or $1 million bank account? I'm not so sure I would want my kids to do that. I think they're fairly responsible, but thinking about what would be kind of some advantageous ages for them to receive. Okay, well, if I die before that child turns 18, but I don't think they should inherit everything or anything at 18, but maybe it's when they're 20 and they have a little more knowledge about the world. But maybe I don't want them to inherit all of the assets at 20. So you can do certain things where they receive a certain amount at 20, they receive another amount maybe at 25, and then again, maybe they receive the rest at 30. So that's called ages and stages. We can kind of pick different ages and stages of their maturity, their life awareness in which they can receive. Or you could just say they receive it all at one time at a certain age. So it just adds that level of control so that you can set up the way that your children would receive assets upon your death. You can designate guardians for minor children. So again, a child who's under the age of 18, you would want to be sure that they have an adult, a caring adult, who's established to take care of them. Now, one thing that you want to be careful about is if you think about that guardian who has the child or your children and is needing to make certain decisions for him or her and needs money for that. Well, when you're designating your trustee, might be a good idea to have the trustee and the guardian be the same person so that the guardian's not always having to go back and ask, Mother, may I, sort of, to the trustee to get access to funds. So that's just kind of a little tip there. And then you can provide a trust to protect property from creditors or beneficiaries. You can provide a trust to ensure property is available for surviving spouse benefits, but is then required to pass to the deceased spouse's children on the death of the surviving spouse. What it says is that you can have a trust where property passes to, let's say it's a second marriage, and you have children from the first marriage, you remarry, now your spouse will receive your property in trust, but when that spouse dies, the trust says everything goes, whatever's left in that trust, everything goes to your children. Does that make sense? So that if your spouse remarries after your death, it doesn't go to that new spouse or that new spouse's children. It goes back to your children. So you can have that kind of control. And then the other thing about your will is that it allows you to designate what's called an independent executor. And that's really key in Texas. Texas is one of the states where having an independent executor allows you to have what's called independent administration. Independent is that it's independent of the court. So what this allows is for probate to go very smoothly, generally, and outside of the hands of the court. The court really doesn't, outside of a few formalities, doesn't require a whole lot of interaction between the parties, and that's much different than some other states. So if you have everything going according to the will, your independent executor is doing what they're supposed to do, managing the assets of the estate, then you can get through, within a few months. It's not as costly and it's not nearly as arduous as some probate processes are in other states. So we're going to look first at the Cleaver family and see what happens when Ward passes away without a will. Because they've had no children from a prior marriage, they've only been married to each other, everything in Ward's estate passes to June. But there's one thing I wanted to point out. If you'll look at the very top up here, there's 1/2 community property. So in Texas, remember earlier I mentioned that it's key if you move to a new state that you want to look at, you need to know what kind of state you're living in and look at how that would affect your will. Texas is what's called a community property state, So what that means is that there's a presumption that all of the assets of a married couple are community property. So the wife has 1/2 of the community estate and the husband has the other half of the community estate. So when Ward dies, his half of their community estate passes over to his wife, June. So now she owns 100% of the community property estate. Make sense? Okay, so we're going to pause there. There's something else that you can hold called your separate property. Separate property is property that you come into the marriage owning, or you can be gifted it or inherited. You can inherit it, and that is your separate property. So unless you do something that converts it in some way into community property, it remains your separate property. So that house that you might have inherited from your grandmother in your name only is your separate property from the marriage. And so those are things that will impact how you might want to leave things within your estate plan, within your will, but it would also have an impact on how things pass if you do not have a will. All right, so looking at a little bit more of a complicated distribution, we look at the Brady family, and in this one, Mike dies, but instead of his property, this is without a will, instead of his property going all to Carol, instead it all goes to Greg, Peter, and Bobby. And Carol receives nothing. Okay, so you can see that there's things that can happen, maybe not according to your wishes if you don't have a will in place. So true or false, if you don't have a will, there's no plan in place. Right. So we just answered that one with false. There's no plan that you developed in place, right? So as you see, even if you don't have a will, yes, Texas will help you get something done with your estate. It just might not go according to your wishes. True or false, if your property is in your spouse's name only, then I shouldn't say your property, but if together you guys have some property, but it's only in your spouse's name, then it's really only your spouse's property. It's only in their estate. False, right? So, I've heard of some people that fall into the trap of, well, the house that we both bought is only listed in my spouse's name, and so we're good. It's all in her name. So if I acquire certain debts or something, they can't get to the house. And there are certain things in Texas, we won't get into that tonight, but certain things that can protect your home if it's where you live. But in general, it is still considered your estate, part of your property. Okay, and then true or false, your 18-year-old can inherit your assets outright. Any amount of cash, anything. True. So keeping that in mind when you're doing your estate planning, you're thinking about how could a trust, we'll get into, they're called contingent trusts, but how could those trusts be utilized so that your 18-year-old isn't walking away with some really big assets and they're just trying to figure out how to, keep their dorm room clean. So just a little bit of food for thought there. All right. So the next document, before we move away from the will and testament, are there any other questions about those? I'm of the second line of thought. So her comment, could everybody hear? The question is, or the comment was, there's two lines of thought. Avoid probate at all costs. The other one is probate's really easy in Texas. And I'll say that I see it the second way. Probate is really easy in Texas. Going back to that independent executor, independent administration of the estate, you don't have to have the court incredibly involved. In other states, California, some other states like that, they're very into every step of what is happening. And what that does is it creates kind of a, stop, go effect on trying to move through the things that need to be done in administration of the estate, because you're always having to go back and check with the court or report to the court. But that also creates more expense because you're dealing with court costs, you're dealing with attorney costs. Whereas in Texas, really you go through the process pretty quickly, and barring any snags, you can be done in a pretty reasonable amount of time. Okay, so the question was, if you download a will form off of the internet and you complete it yourself, would you need to come into a law office to have it notarized and do all the formalities? That's a tricky one. Honestly, I would have to say I wouldn't be comfortable signing off on that, because there's certain aspects that I would want to know are in that will, certain language, certain clauses, terms that I would feel more comfortable knowing that we provided within the will. There might very well be a firm that would be willing to do it. I would not be comfortable. All right, so we're going to look at the next form in our packet. That's the statutory durable power of attorney. And the statutory durable power of attorney grants authority to a designated agent to manage your property on your behalf. This document is distinguished from the living will and the medical power of attorney, which relates to healthcare decisions rather than decisions concerning the management of your property. So all of that is to say this document allows your designated agent the power of attorney to handle your property or more financial decisions if you're in a situation that you can't make those decisions by yourself. We're going to do a quick multiple choice. A few of you are familiar with the Friends TV show. This is Ross, and Ross has had a couple of marriages. This is his off and on girlfriend, Rachel, and over here is his sister, Monica. So Ross starts, clearly he's making some questionable decisions already in his fashion and in his teeth whitening venture. But Ross is starting to show signs of really not being able to make good decisions. He's not handling his financial affairs well. He's not paying bills on time. There's some question as to whether his mental capacity, and I'm sorry, I'm making this all up. I'm sure Ross is just fine. But whether his mental capacity is such that he can manage his own affairs. But he doesn't have a durable power of attorney in place. And we're even at the point with Ross that the medical staff that is working with him thinks, well, I don't know, maybe he's not really able to make good decisions for himself. So in this situation, who can make decisions on behalf of Ross to make sure his bills get paid and make sure his bank accounts are taken care of? Is it A, Carol, his first wife, B, Rachel, his longtime friend, sometimes girlfriend, Monica, his sister, or none of the above? None of the above. That's right. So I've had instances where a loved one will call and say, hey, my mom, my dad, my loved one is in advanced stages of dementia. We don't have a durable power of attorney in place. Can we get one? No. You have to be competent to be able to enter into a durable power of attorney. So what happens if you get to that stage, and I'm like off again, on again. If you get to that stage and you don't have a durable power of attorney in place, you'll have to go through guardian, or your loved ones would have to go through a guardianship proceeding, which is very costly and very time consuming. All right, so our next one is the medical power of attorney. What this document allows is for your named agent to make medical decisions on your behalf. Now, of course, this happens once. Oh, and I apologize. Let's back up real quick. One of the things I did want to point out on your statutory durable power of attorney is it can become effective immediately, or it can become effective upon your incapacity or disability. And generally, people will want to prepare that to be effective immediately. And the reason for that, again, you want to protect your documents. But when the time comes that your agent needs to gain access to that, they don't want to have to wait for the medical staff and for whatever declarations need to be done to have you declared incompetent. But now that obviously opens up some risks. And so you then have to say, well, okay, maybe I would rather have it upon incapacity, and that's perfectly fine, and that is an option as well. All right, so on the medical power of attorney and the HIPAA release, I do those as two different documents. It's possible to also have them as combined, so some people do it differently. The medical power of attorney allows your named agent to make medical decisions on your behalf when you're in a situation that you can't make those decisions for yourself. The HIPAA release allows the designated agent, your family members, to gain access to your medical information so that they can make an informed decision on how that medical treatment should go. And then our last document within the estate planning package is the Directive to Physicians, the living will. The living will is probably, I would say these are end-of-life type decisions. And this is, kind of back to what Kayla was saying. This is where you're thinking about your loved ones, thinking about the position that your loved ones will be in when they have to make a decision. What do we do when in this terminal situation? So the form will allow you to say, I want to remain on whatever life-sustaining support I need to be on, knowing that I may never get out of that situation of needing that life-sustaining support. Or you can make the choice to remain, or to have those life-sustaining measures removed and have what's called palliative care, so just be able to pass away in comfort. So those are the decisions you can make on your living will or your directive to physicians. And then I think somebody was getting into this earlier, talking about, over here we were talking about how do you minimize what has to go through probate. Again, as Kayla was saying, you want to do things that make it as easy and as streamlined as you possibly can on your loved ones and not have to do some of the things, even as easy as it is in Texas, do as much as you can to keep things out of probate. And so you have what's called non-probate assets. Most of the time, those are your retirement accounts, your life insurance where you can name beneficiaries. You can also have joint tenancy with right of survivorship or payable on death bank accounts and savings accounts. You can have transfer on death deeds so that you leave your property, your house, to somebody else and it passes outside of probate. So these are other strategies that can be used. Now, I wouldn't do this and not have a will, because inevitably something would get missed and you need somebody to kind of take care of those other assets that aren't passed directly to somebody else. But these are other strategies that can be used to pass your assets on to somebody outside of your will. It's really wonderful getting the opportunity to talk with you. Please reach out if you have any questions. Thank you.